Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Jacob, any idea of anybody that's with us so far?
Currently, no.
Okay, so for the public, and anybody that may join us and zoom in, this is the beginning of the hearing on the agenda. We have under new business, Judge Germano is here to, I'm not quite sure.
I'm here because I think it's time to resolve the issue regarding the township communicating with the assessment office a no objection note to the joinder deed. And so I have a proposed resolution.
Just give me that there
Copies
for you.
each of you.
Oh, so that's your copy then, huh?
Oh, okay.
Okay.
Jacob, you have one?
Yep.
Okay.
Thank you, Brian.
You're welcome. And so that would cover the note that needs to go over to assessment, saying that the township has no objection to the joinder. Now, you all understand, the township doesn't have plenary authority to approve or disapprove a joinder. It's up to the property owner. But the township does have a right to object to a joinder deed if it doesn't include the language, the above parcel shall hereby become merged into one parcel for taxing purposes and shall not be separately conveyed without prior express approval of the municipality as provided by law, or similar language. You can see from Exhibit A, which is the joinder deed, that language is there. I would therefore suggest that there is no ground on which the township can lawfully object. And it needs to fulfill its duty by sending a note over to assessment saying that there is no objection.
Judge, I'm in receipt of this from Cindy Tribal.
Mhm.
And when it came in with everything in order, except that I don't remember, and I can't find anything about a public hearing where we okayed it. You did this, I think you did this on your own, is that correct? And then it was after the fact that, and the reason Judy does that, they don't want to do a recording of these deeds unless the township signs off on it. That's their principle, not mine.
Okay. I'll take us back then in time. I applied for a building permit. And there was a discussion regarding the septic. And I was told at the time that I didn't have to go to a meeting. Just go ahead and file the joinder deed. And it was okay. And thereafter, the building permit was in fact issued. So I think there may be some mixed signals
Could be.
in the township, but it needs to be resolved now.
Well, I think the intent was, and it could be definitely mixed signals, was that you were supposed to submit the joinder deed to us. And there's a fee that accompanied it. Not that that's any big deal, but that's where we were. And when I got the note from City, it stated January 29th, 2020. I had went back to look at our records and our minutes to make sure that I wasn't missing something.
Well,
The joinder deed is fine. It's as good as any. But what we asked and what she says is that we have to sign off on it.
well, the township can opt to sign off on it or not sign off on it.
Okay,
If you say you want to opt to sign off on it, then you can sign off on it.
I didn't know that.
Okay, so sign off on it. I don't see any issue with it.
When, if I may interrupt, Mr. Chair, when the tax assessment office says sign off, it basically mean approve. So this resolution would be fine. Normally, we send a letter to the tax assessment office saying that the township has no objection to the merger of the properties and tax numbers and blah, blah, blah. Thank you very much. So
Right.
rather than send a letter, the judge has already done a resolution. That works just as well.
Well, the letter's here. All I'm saying is that Cindy simply says that at a meeting on September 25th, 2015, with the supervisors, it was determined that there were no grounds for objection, and they agreed. And that's
Okay.
fine, except I can't find any record of the meeting.
I've got two notes in my file for a meeting, the
Yep.
September 25, 2015 record.
Right.
And then I also have a record noted as March 2nd of 2016. Now, I don't have those meeting minutes in front of me, but my record reflects, or my notes reflect that in both of those meetings, the merger deed was referenced.
I was here
Okay.
sitting in the same chair, and I was told I was free to go because it would be handled.
Okay.
I would, to rectify this and to save the embarrassment of this should have been done at some point in the past, and whatever the confusion was. I'll make a motion to accept the resolution as the judge has written it. And I'd also like to add in that numbers of these properties could appear on our GIS, which are 673-220-303-2611, 167-322-030-30781, and 167-322-03-03-2839. I believe those are correct, aren't they, Judge?
I believe they are.
Or the tax code numbers themselves are, we can refer to also.
Yeah. Well,
And that would
those
be
are on the
most
resolution, but the GIS numbers aren't. So
No, what we can do is if you want, you can put a little asterisk by these numbers and then go underneath where Brian signs with a little asterisk, and the tax ID numbers are bumpity bump.
well, maybe Julie, can you just write that on from my list?
Or you can write it on, however you want to do it, but
Well, I think we should sign this now and get it over with. Do I hear a second?
What was your motion?
Motion is to approve the judge's resolution as it stands.
And can you explain the resolution to me? I'm seeing it for the very first time. It's a resolution.
To approve the joinder deed of these three properties.
That's it.
Yeah.
Well,
the Board of Supervisors presents no objection to the aforesaid deed. That's what the resolution.
Okay,
Okay.
well said.
So we can do it by resolution, or I could respond to Cindy directly and
Either
say
way,
it.
right now you have a motion on the floor. If it passes, you can do the resolution. If not, you can do it some other way. But either way, as I had said before, I saw no problem with the joinder deed.
Well, in that case, I'll second the motion to adopt the resolution as presented.
Okay, all in favor?
Aye.
Aye. Motion is passed.
Thank you. I also have a second resolution,
Oh.
which deals with the rest of the issue. Because if you recall, the discussion was that I would join the three lots together. And then there would be an approval to split off some of that land into a separate lot. And I would point out that there's an important point overall here, right? This was all farmland. It was carved up into 1 acre lots. I am wanting to reverse that trend. So this is adjacent and abutting to another 19 acres of land. The intent here is to have a 23-acre farm. I'm taking 4 1-acre lots and actually reducing that then to 3 acres. I'm sorry, to 3 lots, each an acre or more. And I have an enlarged map for everyone to see.
Thank you.
Um,
Thank you.
And
I think I've got this.
yeah, this is enlarged so that it's easier to read. And I also want to point out that there was a discussion of this. And it was agreed that I would join lots 26, 9, and 6. And then the township shall grant approval for subdivision of that joint lot into 2 lots along a line as depicted on the site plan attached here too. And that lot line would be the dashed lot line. So these 3 lots were joined. And then if we draw this dotted line and split this off, what we end up with is lot 7, which was untouched. That's 1.04 acres. This new lot, that would be 1.13 acres. And then the dominant lot, 26, which would be 1.9 acres.
And that's, Judge, I'm sorry, the 1.9 acres is
Here where the house
Right.
is.
where the house is going to be. Right?
And you can see, at least from what I see here, Mr. Chair, is that if you follow those dotted lines, then the well and the septic, et cetera, are all on that one lot now.
And that's the only concern that the SEO had. And that takes care of it. And the reason he probably had a concern was that it hadn't been recorded. And that we'll take care of that. We were already taking care of that.
I believe he was told by the zoning officer that the lots were not joined.
Dave Matter was the SEO at the time,
Yes.
sir. And what he did is he came in, he looked at it, he looked at the records that we had. And at that fact, they weren't presented as joined. And ergo, he said he couldn't do that.
Okay. I submitted an application for amendment to the septic plan. And in it, I enclosed a copy of the joinder deed. I am informed that someone up here told him that the lots were not joined, that I never filed the joinder deed. And that was misinformation, it was incorrect.
I don't think that was the case. I think what happened was that somebody up here possibly went to the Recorder of Deeds and found out that they weren't joined. But the only reason they weren't joined is because Smithfield Township was remiss in signing off on them.
I think that's a misstatement of law. When I filed that joinder deed, those lots were joined.
Well, why did Cindy Tribal say that they're pending being recorded until the township signs off?
Because when you do the no objection and you acknowledge that that sentence is in the deed, it changes the taxing of the lots.
Which is certainly.
I actually get a benefit on taxes when you send the no objection communications. It's to that which she is referring. She's not making a comment on whether the lots are legally joined or not. She's talking about squaring away the taxing number.
Yeah, and then very briefly, she does said, listen, in order to carry through and have this recorded, we request that the township agree and sign off. And that's where this thing got.
Again, it's, I understand that non-lawyers may not have an in-depth legal knowledge. The township has no authority to approve or disapprove in the sense that it can plenarily say whether it's done or not.
You please refer to our solicitor.
The township's only concern is whether the deed contains this language. And on that basis, if it's lacking, the township can object. If it's there, township can't tell the property owner that he can't join lots. There's no zoning issue involved here. I'm not trying to join residential to commercial. There's nothing that the township can possibly cite that would be an objection, a legal objection to joining these two lots.
Judge, do you have another copy of this map or not?
You can have that.
Not that I marked it the wrong way. I want to mark another one. Yeah,
You can have mine if you want.
Here. Just wanted to mark the lots. I put these yellow lines down before. What the judge is saying, Mr. Chair, is that, and he is correct legally, once the deed is prepared and filed a record as it was, I believe, in 2016, the lots have been legally joined as a legal matter. However, tax assessment would not recognize that joinder.
Would not record them.
Well, no, the deed was recorded. They would not recognize the joinder until there was a sign off by the township. So that's what they were looking for. But the deed was formally recorded in a deed book, whatever number it is. There it is.
I refer your attention to the last page.
I had that.
Okay. That is receipt showing that it was legally recorded. Your solicitor is absolutely correct.
So that was the issue. So now that's been resolved by way of this resolution acknowledging to the tax assessor's office that the joinder deed is acknowledged, there's no opposition, whatever word you want to say. So we're good now with that.
And that's the second resolution.
The second resolution dealt with the divisions. And just give me a second here because I was marking things up as we were talking.
Division of lot or whatever,
Approval of the minor subdivision.
a minor subdivision.
I
But
joined 3 lots and
Right.
that amounts to
tell the difference
over
between
3
two.
acres.
Between, oh, hold on for a second. Got to get my copy here in front of me.
Well, Judge Romano, but the on-site sewer system will be on part of those adjoined lots.
Resolution that talks about the subdivision, et
Correct.
cetera,
Right.
No.
which is here.
Yeah, it has to be.
And this is the one that talks about, oh, it's the same thing.
Yeah.
The same
Lot
one.
that
Yeah.
would be
Okay.
split
Sorry
off.
about
Yeah, the other one would read like this.
It does not touch lower septic.
That's
Right.
our merge,
But I mean,
et
you're-
cetera,
you're-
et
you're
cetera.
well in
So this is-
septic.
That's why they're.
Are going to be on
Okay.
the- on this
Yeah.
parcel of land.
Okay.
This newly created joinder to
On the 2016 created joinder, yes. The well and septic and house are on one lot. That lot was joined in 2016.
Right.
With the understanding that I would be allowed to split off the remainder of lots 9 and 6.
as long as it didn't take the sewer treatment, but and it you, okay.
And as long as it exceeded 1 acre, and it's 1.13 acres.
Do you have another copy of your second resolution? I
If
got
not, I'll go make a copy for you, Jacob, if you need one. That's the one that deals with the merger, Your Honor. If not, I'll go make one for him real quick.
I can give you my.
Well, don't give him yours. I'll go make one. It'll only take a minute. Give me a minute, I'll be right back.
It never takes a minute.
Wow, okay, couple of minutes.
Okay. So I guess what I'm seeing, and I'm seeing a lot of this and talking to you for the first time in a long time on it. I wasn't involved in any conversations prior to this. I think Robert may have, and maybe even Jacob, and I think Ron. So again, forgive me if I'm just saying for the first time, though, I'm seeing this second resolution. The explanation of our solicitor, in my understanding, is that it's something that certainly is allowable, and we should move to allow it.
As soon as Jacob gets a copy, we can entertain a resolution.
So a synopsis right now, as I'm looking at this, 3 lots joined.
I don't know, that was pretty close to a minute.
Very good.
Thank you, Ron.
Not bad for a Canon's copier.
Or an attorney.
All right, so then you have the other resolution.
Yep.
In front of, I don't know what the resolution numbers are, Julie, we'll put them in due course, you know, because
Well, if no one else is speaking up, I'll make the resolution. To approve the resolution, motion to approve the resolution. Township shall grant approval for a minor subdivision of 3 joint lots into 2 lots along a line as depicted on the site plan attached here.
I'll second that motion.
Okay.
All in favor?
Aye.
Aye. Okay. So,
all right, so we should be good here, Your Honor, as I told you on the phone the other day, probably my fault in not paying attention to this, so I apologize, but I'm glad we got it done.
Okay. Um, Thank you.
Thank you.
And I'll go ahead then with the rest of the project.
Okay.
All right.
can, Judge Romano, I think everything's in order, but your permits may have expired.
Permits don't expire.
Okay. They're on. Well, I'll tell you what, I'm learning a lot.
Well, if you read cases like Turner.
Did I, sir? No, I would
No, I'm
expect
saying
my,
if you do, you'll see that the prevailing legal doctrine is once a permit, always a permit. Now, the building permit can expire if you don't start within 2 years. We started. The house is under roof. So there's no issue with the building permit expiring. There's no issue with the septic permit expiring. And the blasting permit is over and done. It's already a house built.
okay.
Okay? So I'd like to ask them regarding getting this communication to Ms. Tribal over at assessment. Get a copy of the signed resolution so I can bring them over.
Yeah, sure. Well, yeah.
If
that's
you
what I'm
gentlemen
gonna-
want to sign it today, you can, but we got to get a number from Lois if she's still here.
How about we get the
Oh,
number
Lois is
tomorrow and
left.
I drop it down to you?
About tomorrow, then, Your Honor, so I give you the resolution number on it from Lois. And then we'll drop it off down below for you.
Okay.
And if it doesn't happen, you call me, because I don't want to be in the same situation as we were again. So, and what we'll do is we'll get a resolution number on both of them. This way, then you'll have a copy of both resolutions, one for the subdivision and then one for tax assessment. Okay, so if you could allow us to do that, please, Your Honor.
Yes, thank you.
Or no, thank you. Thanks for those, the email with the cases and stuff, Judge. That was helpful.
Thank you. You're welcome. I'm sure the rest of your business is
Riveting, however, you can,
bound to be captivating.
but you can leave.
You're more than welcome.
Thank you.
Thank you. Long day.
Yeah. Take care.
Okay.
Enjoy the night.
All right.
Okay, so then all we've got to do is add the resolution numbers to it. Take it downstairs, sign off and take it downstairs to the judge and he's ready to go.
Sounds great.
Now, the permit stuff, that's not under our control. I'm hoping that we don't have issues with Ken or treasurer's office with those permits, but we may have to readdress this again if in fact. Because I don't know if I agree with him that permits don't expire, because he already told you that a building permit can expire. I really haven't done the research regarding the sewage permit. That's really the one that he has, I think Mantor had an issue with, but he's not the SEO now, so who knows?
Manford's only issue was, it was at that time, not on the property that you wanted to build a house. That's been taken care of.
Right,
So,
that's been taken care of the way he had it, correct.
and the fear really was that after the minor subdivision, what goes on? What if he did want to sell it? And Jacob bought it and
Right.
found out that he couldn't perk it.
Yeah,
Or
that
he had no sewer.
that would be a pretty bad situation.
So it's
there.
sure, it's an assurance for anybody that's getting involved with it.
Didn't even know that there was that much back there. Actually,
Yeah, he's
not
got-
far from me at all.
And I think the acreage needed back there is what, an acre to build?
Right.
Up where he is, it's R1.
Yep.
So it's an acre?
Mhm.
Yeah.
So that's why even like here, see where it's, the new lot is 1.9 acres with his new house?
Yeah.
It would even be difficult, because normally, you know, he said, I want to make it through 23 acres, whatever. You normally would say, well, then you need to do what's called a consolidation merger deed for everything. But, that just now becomes another issue, so it's best to just let it alone. And let he and the assessors fight about it. We're out of the loop.
Well, get us out of this loop. It's been a 4-year loop. Okay.
All right.
All right, so we've got our task for tomorrow. Julia will make sure that we're notified. And let's move on to the second item on the agenda. This is discuss the buyer's agreement and estimate of closing costs for the Marshall Street Falls house belonging to Anthony and Diane Maglioshia. Okay, what I had in front of me was the seller's agreement, an old one.
And a new one. We have both of them.
But the new one was, I guess, was developed yesterday.
Within the last 2 days, yes. Should we talk about the history of this and why we want to buy this house?
Well, listen, if you want to, I'm gonna have to correct you several times because some of your assumptions were off the wall. Okay, but
What is off the
basically,
wall?
some of your
Well,
assumptions.
tell me which assumptions you think are off the wall.
About
You know,
nobody didn't think it was terrible. You just went on and I have the email if you'd like me to get it, read it to you. What you simply said was, it's been going on too long. Nobody's getting anything done. It's helter skelter and all of that.
Correct.
It wasn't. It was right down to the last minute. Everything was in order, approved by DCEV, Christine DeTore, access from the parking lot that had an HOP, that we accessed the entire park itself. That fell through after it was
by
submitted
Penn,
and
because of
signed.
PennDOT. Right?
No, it fell through because of a renege on the Scott family.
Well, wait a minute, we're talking about two different things. The first thing is, originally, and this goes back before I was ever elected.
Yeah, I know that. It was obvious.
The master plan for this, which never, and I didn't know this until we came up against this problem, never included either an option on an easement or purchase for a parking lot.
Yes, it did. And his lawyer has it to this day. I called him again and begged him for it.
Brian, this is before my time, so I have no idea.
That's why I'm saying, please communicate with me. I can save you a lot of verbiage.
All I know is in 2017, we got 2 grants, DCED, DCNR, and suddenly we found ourselves without a parking lot and with,
No, we had them or we wouldn't have got them. We had a verbal commitment.
but that's not a commitment.
All right, the attorney said that this was a done deal. Here's the document right here, okay? And what he
But wait a
said
minute, is
was
this a verbal commitment?
No,
With Scott Brothers.
written
Or the
with all the
Scotts Brothers.
parameters
Yeah.
involved with
Once going that.
it.
I
Okay?
agree. They
And
did
what
renege.
happened was, It's submitted, it's okay, everybody's ready to sign off, including the Scots. Next day, we had a problem.
And what happened?
They were served by our zoning officer and our building codes
Right, but
officer.
they-
The very next day.
But wait a minute,
felt
they
that
still
it
had,
was-
they had still had an agreement on paper to sell, or to
Right,
give an easement.
to give this easement, and the easement was drawn out, well described. It had its parameters in perfect shape, and it was put together by their attorney at that time.
Why
Was-
couldn't we have held them to a written agreement? I don't get it.
Because we did have, and it was agreed upon verbally that it would be signed on Wednesday, on Tuesday, they got cited, and that was it.
This is before my time, so let's move on.
The
Well,
easement
let's move on.
agreement
You
that I
just-
prepared for the Scots.
You just
the one I
asked for it,
prepared,
right.
They never signed.
Let's
So
go- let's
we
go
go
on
Yeah,
for
on
but their attorney did say.
They made changes and I made changes,
And
whatever
so
we're
we
gonna
had
sign, but
the
they never
agreement,
signed.
okay?
So
You
can't
asked for
hold
the
it.
recap. I didn't want to get into.
Oh, no, I never heard this part of it.
Well,
But let's go on to the
because you
next
don't
part.
Listen.
Let's go on to the next part,
All right.
where, because of this,
Got
we tried to make a road cut, a new road cut, and maybe establish a very small parking lot to see if we could hold something open until we could find a way to do a bigger park.
And that site was decided by DEP and us, and very simply, it was the only accessible part, and to
Right.
this day, it is the only.
It is. And what happened after that was PennDOT first approved or preliminarily approved and then disapproved because the driveway for the house we're talking about in question was too close, right?
They didn't disapprove. All they said is that you got remedial action. It's not going to be much. Brian himself said it's doable. Don't worry about it if this is the case. Then we started to talk about, let's do this. We still need the HOP down bottom. And that is something that is a work in progress right now. So what
So
we want to do really is eliminate,
right, when you speak of Brian, you're really talking about Brian Smith
sorry,
and Barry Isaac, who's the engineer of this, and
go by Brian Smith.
others. His view was, okay, the easiest, the best way to get this going is close off the existing driveway that goes to the Magliosi property, make the new entrance through the cut that we've got, let's say, tentative approval on, and then demolish the house and make that the parking lot.
Eventually knock that down and make it a parking lot.
Right.
Enter through the same HOP that we still have to
Yes,
continue to
right.
get.
We would use our cut
But
and just
right
swing the
now,
driveway.
that's
around.
why I said in my email to you, we still have to continue on that. That could
Yeah.
be,
Oh,
that
absolutely.
could be a fallback. And if something happens with whatever's going on in this particular purchase, then we would need to have that fallback. The fallback would entail putting a relatively small parking lot in that site, but safe entrance.
Wait a minute,
and
if we
egress.
do have if we do get the HOP to that site, we can, and this is what Brian came up with, we can swing the road up the hill towards where the house is now and close off the driveway that was causing the problem that comes from the
Right,
house.
yeah.
Right?
Where you at?
Yeah.
It's close off the driveway that comes from the house. And again, I read your email where you suggested that we move that. And actually, you really on your own went to Tom
No,
McGowan.
I didn't.
Yes, you did. I want this as add this to the seller's agreement. Access, Tony will allow
Oh, I
access
added
by
that
us.
because
Boom,
it was
boom, boom.
obvious, if we were gonna destroy
Okay.
his
I'm-
driveway, we had to give him access to another driveway.
Right.
So that's how that happened.
Okay, so what that does is that brings us up to where we almost are now.
Okay,
And where we are now is a situation where we had gone out, we had it appraised by a reputable certified appraiser
correct,
at $135,000.
125,000.
125, that's right, we want to pay 135. And as Ron has said, and it's in here, I made a note of it, in the second class township code, you cannot pay more.
Right.
Okay, now, I don't know what happened yesterday, but from the first or original seller's agreement, something happened here. This is the new one.
Right, because we couldn't, I've held my tongue at this, but I have to say this because it's part of why this price is where it is and what we had to do. When I went to the Realtor, I assumed we'd have to pay fair market price or near it, whatever it happened to be. I didn't know.
The appraisal.
Appraisal. He then went to the seller, and the seller reported, which he reported to me, that you had told the seller that it was worth $140,000.
Can I correct you there?
That's all I know.
That is terrible. You know, like, even to quote that. Here's what happened. Tony got his son involved.
Tony is the seller.
Tony's and his son is the.
Okay, but I'm making it clear for the
Anthony.
record, who is whom here.
Anthony is the
Who's
seller,
who?
and Diane, his wife.
Okay,
And he said, no, I don't want to do this yet. I got to talk to my son. He's my financial advisor. He came back and he said through whatever connections that we would like $140,000. Somehow that verbally got to me and verbally said, Tony, we cannot do that. We are limited to the damn appraisal of $125,000. Boom. Then I'm seeing, and one day, a total change, and it's a significant change to that agreement. And I asked you, I saw, it's verbatim for the email you sent to Ron when Ron told you that you couldn't do that. And then you went on, and then
then what I did was I had to figure out some way we could acquire this house because I think it's crucial to continuing this park, to have this property and to be able to continue
well, and it
find a
is.
parking lot.
It
Otherwise,
is.
we have no parking lot. Wait a minute. So I went to Ron. Ron, would you, collaborate what I'm saying?
I'm sorry, you
This
went to
morning.
Ron?
Ron, and I
Yeah.
said, Ron,
When?
this is what, 2 days ago?
No, I think we had this telephone conversation, it might have been as late as yesterday, but it could have been 2 days ago, but it was
I
current.
said, look, if we can't pay more than fair market price, we're not going to get this guy to come down $15,000 or what, $10,000. All right. However, could we do something else? Could we say, all right, we've asked you to move within 3 months. We know that this is a hardship for you because your wife is ill and you wanted much more time. If we do that, can we pay you something for your moving expenses and your reimburse your costs of getting out and going somewhere else because we want you to get out of this property. And you and I discussed that, and it seemed reasonable.
Okay, I don't know if it was you and I,
The
but
price is still the same. It's just we're dividing it differently.
well, that's when I sent you that email, and all I said to you was, be careful. You're in a situation where and it's not DECED, this is the second-class township code we're dealing with. And if they feel that we're doing something, and it looked to me like it was kind of a out of the blue.
I didn't suggest that
You
to
said-
the
you
realtor
suggested
until
10,000.
Ron and I had talked.
No, you suggested it in your email to Ron, $10,000.
But then I talked to him. I only talked to him after that to say, am I
That's
right
it.
in doing something like that? I wouldn't have done it unless I had gotten his okay. I would never have done it without
So Ron, you
counsel.
said yes.
I had said, I think that works, but it gotta be on the agenda for today for a vote.
Right.
I said, I believe that might work, but it's gotta be voted by the
Well,
supervisor.
here we
And
are.
again,
We're here to vote on it.
and your advice is that you don't feel that there's any manipulation, if you will.
I don't know.
That
I mean,
price.
I'm trying
It's
to guess.
it's
what
scary
occurs.
grounds. And what
If in fact they give us invoices to show us what they are incurring for moving early, and those invoices total 10, I think we're okay.
Okay.
But
That's
if
what
we
you told
just
me.
give them a check for 10, now I'm on your territory.
We've written this as
That we
up
might
to,
be,
up to
we might be
10.
close.
So we've written this as up to 10, so they have to
So
justify.
I think we're okay with that, but I can't predict.
I don't know how
Guarantee, Brian, who knows what like a Zulik would do? That's what I
Okay.
told Robert. I said, I don't know what Zulik would do if this one.
Is he?
I
But
do
we never
know
know what
this.
he's gonna do.
I've got enough experience to know that if they think you're even playing cute with it.
Yeah, I agree.
They're gonna jump all over us. And that's all, that's why I said to you, I'm not protecting you, but I'm protecting all of us. We get into this situation, and we could be in,
But let's see, let's look at
agreement.
the other side. Practically, we have no choice. We should acquire this house. We should tear it down next spring and we should build a parking lot. So two things can happen. First of all, that we can turn a spade this year on something
The judge that would hear a
on
case
this
like that.
park, so that we're in construction on it. Because
Right,
I'm
'cause I
also
don't know his
terribly
specialty.
worried after what happened with our green
Yeah,
light
that
to
was
go
that specialty.
grant that was rescinded by PennDOT, that given the economic climate, we could lose one of these grants because we haven't done anything. This was 2017. As long as we turn a spade and we're in work, we can say, we're working on it. It's in construction.
okay, so let me bring this back to what we're gonna look now, and it's gonna be a motion. Let me just say that I have some comments about it. I really believe that this has to happen. I was probably one of the first with Robert, myself, Brian Smith, to talk about alternates for it. We had a plan, an HOP at the bottom, and then with, I guess it'd be permeable road to get us up to the level, and then have access to the rest of the park. That was the original. Well, after the original was getting the HOP from the Scott family. That didn't happen. So that's where we went. And that's where we cut the trees down. It cost us $6,000 to cut the trees down so that they had line of sight to
There's some
do
nice
that.
lumber sitting up there, by the way.
I know, and that's,
If anybody's out there that wants some lumber, we'll tell you where to go.
yeah, right. Yeah, and then we could put that down. We'll sell you the lumber, and then we can decrease the price to maybe $90,000. All I'm saying is, I don't know enough about it. I always defer to my professionals, and that'd be Ron. But I thought that possibly we could put ourselves in a position where it's a shootout.
Fine, there's-
And if these people and these bureaucrats think that you're pulling their chain, you know what?
Look,
We could be in trouble.
I'll be happy to be the sacrificial person on this. I'll do anything to get this park going.
Well, you're going to. And then the other thing, and the only concern of mine was how this came about.
How what?
We'll talk about how this came about in one day, a change this radical.
Well, we'd
I
already
never
negotiated.
knew. Nobody knew. How
Well-
was it done? By phone?
By phone, that's
And you
all.
talked to Ron,
After I talked to Ron,
and Ron said, that,
he just reported what he said.
yeah,
I said, give it, you know,
Look,
see if
this
that
is-
works.
what did you say?
I said, see if that works with respect to moving expenses not to exceed $10,000, but we need receipts.
Okay, and I love the reasoning, but moving expenses, reducing the price of the property, it's a non sequitur as far as
You
I'm
don't
concerned.
know how that will work. I agree with you, Brian.
maybe
You
so
might
I-
get some goofy judge give you a hard time if it's challenged. Or maybe even DCED pulling a grant or something saying, wait a minute, you guys are playing. too
I've already
fast
talked
and
to
loose."
Brian.
I don't know.
I've
I
already
just
talked to
don't
Brian
know,
Smith
but-
about that. He says there's no connection.
But
between this and the
Robert's
two
trying to
projects.
think out of the
That's not-
box in order
that's-
to salvage
You
this
asked him the
property.
wrong question. The question you should have asked him is, this is our recommendation. We created this,
Okay,
and we had a seller's agreement as a result of it. And
Right.
we feel that now it's below 135,000. But in reality, we're going to be spending even more. So all I said was that maybe, and I didn't mean to infer that, I think you said, I mentioned the sunshine law. Whatever happened yesterday, and then I'm seeing this today, I have no idea about it. Were you aware of it?
I heard about it when I got, in the email.
Well,
I didn't,
that I got.
I didn't speak to Tom. Yes, correct. I saw this in the email. I did not speak to
That
Tom.
is why,
McHugh.
Mr. Chair, it has to be discussed at this meeting.
right,
Because
which is what
the
we're doing.
township isn't just one supervisor, it's the group of supervisors. So you discuss the matter, talk about the good, the bad, the in-between, and then make a decision. That's the way it's gotta be.
This is a buyer's agreement. We
Yeah,
haven't
yeah,
agreed to anything until we make a motion to accept it.
Oh,
So that's why we're talking about it.
Well, no, I think they need to put a closing on it. There's a date in here, extended it. But
I don't have the new agreement here, I have the old one, but.
If we accept this, it costs us $5,000 in escrow, and I think we have a month to accept it or not.
Well, 5,000 escrow, there's, in the new one, it's going to be a realty commission of $7,500. Then you're going to add the moving asset, $10,000.
Right. If they give us all the receipts.
And if they give us all the receipts. I've been around long enough, and I've played the bureaucratic game too. And I've seen, you'd be surprised. I don't feel comfortable with it, but let me just say this. I'll go and look for a motion in a moment, okay? But I want you to know this. I think that it's definitely the best way to go, but it's definitely not the best time to do it. We're going to go, this is going to trigger an effort that's going to cost us over $250,000. And in this day and age, could be. And in this day and age, revenue's falling. We have no idea where we're going to go to put that out. And guess what comes out August 1st? School taxes. And guess who's got the highest school taxes of the four schools? We do. We're going to see people losing more jobs. You're going to see evictions not too long from now.
Brian, on the other
And
side,
the other side of it, our roads are in terrible shape.
no, I'm talking
and
about
I'm
another
saying-
other side. I'm saying this, you
Yes.
and I and Jacob have had responses from residents all summer about, why is this park closed? What is this? What is this? This park has been closed for years and people want to go there. We'd have to build a park here and get the thing open. This has been going on too long.
No, it hasn't.
I think so.
I know you
It
do.
predates me.
You're very,
And I've been here 5 years.
well, 4.5, but it seems like 10. Okay, here's what I say. I'm saying that you're going to have layoffs. You're going to have evictions. You're going to have another drop, and we've already seen decreases in our revenue. Our roads are pathetic. I'm getting more cars about roads than this park. If there was a public meeting today, I assure you that the citizenry of Smithfield Township would be more concerned with, yes, get to the park when you can. We're going to get out of this. Let's do it. But in the interim, let's not spend that kind of a money when we need this money. Liquid fuels tax don't cover a third of what we need to do. And you know that. You've looked at the
All
whole
right.
thing.
I'll make a motion, all right?
I'm not ready.
Okay, go
Please
ahead.
don't interrupt. me.
Speak more,
Don't interrupt me. You asked me to speak,
all right?
okay?
But do
And
me
the
a
other thing
favor
is,
on this subject. I appreciate not getting any more malicious emails on this, as I have.
they're
the
not
last 3 days.
malicious, they're suggestions.
Well, I've got a file of them. I can show you them.
Yeah.
Yeah.
Well, can I say something?
What?
If you feel that way, if you really feel malicious, sue me. Sue me. I'll take you to,
Brian, I
Okay.
want you to know, there's someone in this township that I talked out of suing you
yeah,
for something else,
yeah.
which I think you know.
Of suing me.
Yeah,
No, I'd like to hear that.
well, I don't think this is the appropriate time. We're on camera here. I don't think you want to hear it here.
Well, certainly I do.
Okay?
Yeah.
It's what you said to Craig about Troy Nauman, okay?
Right. Yeah,
And he called me the next morning, furious. And what he was saying is, I'm going to sue him. I'm going to sue him. I talked him down out of that. Do you remember what you said about him?
about Troy Nauman.
Yes.
No,
Well, I won't repeat it here because it was profane. But you said it on camera here in one of our meetings.
all I
I didn't
said,
want to bring this up,
All
but if you
I
want to get
said-
into it,
all I said in that particular meeting was, oh, by the way, I've got another agenda item. You
No,
can't just do that.
that's not what
Yes,
we're
I
referring to.
started. And I said, who is it? And somebody said Troy Nauman. And I said, oh, F.
Yes,
That's it.
you said that in
That's
a
it.
public meeting on camera about somebody who's in this township. How do
And
you
I
think
said,
they feel?
oh, F.
Well,
right. And you let that happen. You.
I
add
let it
something to
happen?
the agenda. You don't send
Wait a minute.
agendas. You
I
don't
let it
send-
happen. I don't put things in
You
your
don't
mouth.
send agendas to begin with.
I
And all of a
do.
sudden at the, no, you don't. And at the
What do
very
you
last
mean?
minute,
We have an agenda for every meeting.
you don't send.
I don't send them.
Send,
Lois
I've
sends them.
never had.
No,
this experience.
Lois,
All right.
for Christ's sake, the chairman sends. them.
I'm gonna make
Now,
a
here's the
motion.
deal. Here's the.
Are we
deal.
ready for a motion?
No, because now you're going into a thing of whatever.
How about I make a
was
motion
said
to remove you as chairman? How about that?
You know what? I win the bet
What's the bet?
that you're gonna do that tonight.
I wasn't planning to do that,
Sure you
but look
were.
at how this is heated
You're
up.
a vindictive guy. You really are.
All right, I'll make a motion to
Then we'll
nominate,
wait until we do, let's finish.
I'll
this
nominate
motion.
Jacob Pride as chairman. Okay? You want me to do that?
Sure.
All
Yeah,
right,
it's-
I just
it's
made that
just-
motion.
Can
Do I hear a
can he
second?
do that on the agenda?
I would have to check out. It's not on the agenda and I'm not sure if you can make those changes, not at
That was
a.
the Troy Nauman situation.
Not at the
He wasn't on the
reorganization
agenda. You put him
Not
on
on
the
the
agenda.
reorganization.
Oh, by the way, look who's here.
And you used a
And by the way,
profane
look-
word about him?
And by the way, look who's here, okay?
Who?
And I said, who? And you said, oh, Troy Nauman.
He
I
was,
said, with
he was
what?
not here.
No, going back to this instance.
He was not here. I don't believe he was here. Jacob, was he here? I think-
No,
I-
no.
When Troy
didn't
was
show
not
up.
here that day.
No,
No,
he heard it.
but
on-
he wanted to be on the agenda, and
Right,
the
he
simple
was, and
fact
he-
of the
he
matter
wasn't.
is, the agenda was set, and more importantly, I asked what the heck it was going to be about, and you start saying something, and I said, oh, F. That's all I said. I didn't say he was a bad guy. I said, oh, F. It's why is this? You're convoluting
say he
an
was a bad-
agenda.
I'm only
It's
telling you,
against the law,
he felt it was very insulting and wanted to sue you.
and
That's
that's
what
why
he said to me.
That's why he's talked to me about 3 part time.
Okay.
Okay.
All right, where do we go from here?
Well, we've got that, and we need an emotion.
All right, I'll make a motion to accept this buyer's agreement for a total of $145,342.50. That includes the purchase of $125,000, up to $10,000 in moving expenses because the seller has agreed to accommodate us for our time schedule of getting them out of there in 3 months, and all the closing costs and the realtor's commission. So the total is $145,342.50. I'll make that motion to accept that.
Okay, and again, I'll not,
I hear a
Yeah.
second.
involved.
I will second the motion.
Okay,
no doubt.
call for a vote?
Yeah, all in favor?
Aye.
Nay.
I believe that passed, right?
Correct.
In looking at the closing costs here on the list that I received, it looks like the seller is paying their share of the transfer tax, however, correct?
Seems so, yes.
Because we're only paying 1%.
We're prorating.
Okay.
Uh.
That's on the sheet here, Brian, that has the numbers.
Yeah, I have it. I have the.
I don't see them
First
paying,
and
but we're paying the realtor commission.
Yes.
And that's now,
$7,500.
as opposed to the 8,100 it would have been if it
Correct.
was 35, but he,
Well, but no, normally the seller pays the realtor commission.
I'm
not
sorry,
the
what?
buyer. Normally the seller pays the realtor commission, not the buyer. That's why I'm just
Right.
confirming that we're paying
Yeah.
the
we're paying.
realtor commission, even though we're not the seller, we're the buyer.
Correct.
Okay. The rest of the things are pretty much standard.
Because the realtor was representing us.
so what? Okay, I think this is going to be contested, but I'm not sure. You guys did it, and it was a 2-1 vote, so that's it. Okay, let's move on. We have a third agenda, and we got the bids in. I think, Julie, actually, did they come to you, or did they come to all of us? I'm not quite sure.
I believe they came to
Jacob,
Boucher and James. Do we have them here or no?
yes, she sent these down to us.
Right, they came
It
via
should be in your
email. They came via email to About the 3 supervisors and John Tressler.
I don't have it.
You
It's in
didn't
your-
get it in your packet
oh.
yet?
I printed these, well, I only got them like their comparison. So that's the one, this one here is the one that they entered to compare the 2 bids that were received. And then this is their estimate, but Julia, I think, had some notes on the comparisons between those.
Yeah. So first and foremost, just to confirm that Pioneer Construction Company, Inc. came in at a bid base for $34,232. And, oh, I'm gonna screw this up, but Chilwellski Enterprises came in at $45,700. Base bid with alternate item A for Pioneer was $59,967. Base bid for item B would bring it up to $69,232. Going back to Chilwellski, base bid for alternate item A would be $86,700, and alternate B would be $96,700. After Jacob gave me the bid form and the Boucher and James estimate, first and foremost, the numbers between Boucher and James and the base bid are almost double. Obviously, the mobilization costs are different. We can't really control that, especially now with what's going on. The one concern that I would like to express is that items 16, 17, and 18 on the bid form are not part of the Boucher and James opinion of probable costs. I am obviously new to this township. Oh, and also item 11 is not present on the bid form here. So I'm not sure if Boucher and James was in charge of putting this together and whatnot, but that's probably why we're looking at the increased cost, because the 2 forms do not match up.
Okay. Julia, are you going to follow up with this and you're going to talk to, I guess, Missy?
Yeah, I can reach out to them and find out.
See if we
what
can
the
put
next
this
step
together.
process is.
Right. We have no obligation, by the way. We're not going to award these until next week. If
We
we
also should find
decide
out
to.
what exactly we got in the grant. I think it was around $85,000, something like that. It's a 15% match, but I think we got about 85,000. I may be wrong. So
I believe you're right. I think that's ballpark for it.
So that means, let's see. Well, one of them would be within it, but both of them would be within it. Anyway, we ought to study this. It's too complicated to just do here, I think.
Well, number one, there's nothing more we can do here.
Yeah.
All we got to do is get in touch with Shane James.
Yeah.
And then next week, we'll address it. We'll decide yay or nay if we're
Yeah,
going to
fine.
award it.
Good.
So it's been announced. We don't have to take any action on this. And under new business, Robert, where do you want to go?
Nothing I can think of. Jacob, do you know of anything?
Well, we do need to approve the July 15th minutes
And
yeah.
at the top of the meeting.
right, and I've seen them and I have no problem with them and said so. So I'll make a motion, we approve them.
Second,
Aye.
We have bills to be paid.
make sure you
Wait,
call
hold
Bill.
on, call the vote.
We did, didn't we? Okay,
Brian.
I thought I made the
Jacob
motion.
Pride seconded. And then,
all in favor?
Aye.
Aye.
Okay.
thank you.
Okay. Jacob, you looked at the bills to be paid, I know you said, and
I
I did
did.
too, actually. And I have no problem paying these bills. So I'll make a motion that we pay the general fund $68,268.56.
I'll second it.
Part,
Aye.
You have to
well, I was
finish.
going to go all 3 of them and just put it over with. Park Fund, $3,871.92. Highway Fund, $887.34, for a total of $73,022.27.87. And I'll make the motion that we pay those bills.
Second it.
All in favor?
Aye.
Aye. And public comments, are we still on?
If there are any comments, Mr. Chair, in the meantime,
Nobody?
just reminders.
All of that good stuff?
Next Tuesday night is the meeting and public hearing on the economic development.
Yep.
Ordinance.
Yep.
So keep that in mind. Then on Tuesday, August 11 at 7 o'clock will be the public hearing on the landowner curative amendment filed by Water Gap Capital Partners. I keep that in mind. As I said in an email to you, and we can explain in more detail, not necessarily today, but another day. I thought that the enactment of the economic development zone ordinance would cure the defect, because the economic development zone has a specific section for drug and alcohol center.
Yeah.
Unfortunately, our good judges of the Supreme Court stated that that cannot work that way. If you had advertised the ED zone before they filed, you could hold their feet to the fire. So if anyone else would now file and say, we want to put a drug and alcohol center here or there, you could say, oh no, we have a pending ordinance that's going to be enacted. So you have to have a hearing in that matter. You may still decide that it's not the right place to be. And if you make that decision, then that's your decision and you move forward. But you will have to have a hearing. We can't just summarily say we've cured it. Because I thought we could, but again, our judges, that's why I say when we talk about this agreement of sale, et cetera, you never know what some judge might do. So
Well,
that hearing will have to take place as scheduled.
and everything's taken care of logistically. It's been
Yeah,
it's
I put
advertised.
the ad,
It's
the ad
gonna
will be
there.
in tomorrow. It's saying that, note everyone, first come, first served. You've got 10 people at most coming into the meeting room. I sent that to the lawyers and said, you guys fight among your, I'd say fight among yourselves. You guys decide among yourselves as to how you are going to decide who comes to the room themselves as opposed to Zoom. So, and I said there should be 10 spaces based upon what Jacob told me. There might even be less because I forgot to put Ken Wolf in the listing, but Ken may not be here, for that hearing.
We could put them in the room, and if we need them, we'll call them.
There you go. So in any event, so that's set to go, assuming Ken now has to post that property 1 week ahead, just like any other amendment.
Yeah.
And then that's ready to go. If in fact the board denies it, then there has to be an ordinance or a resolution denying it. If the board believes it should be allowed, then also there needs to be a formal ordinance, et cetera, adopting it, if you will.
With our conditions.
With conditions. I mean, right now, they've already added one condition. And one condition is that it's 25 acres. The other condition is it has to be a conditional use, that they just don't get it, that they have to have a hearing before the
Right.
Board of Supervisors to determine what reasonable conditions should be included. And as per the Planning Commission, the Monroe County Planning Commission review, they said to consider, security, fencing, this and that, and all that other stuff. So
And they did mention the ED zone too. But you
So,
never know with these guys, Ron. We're gonna have at least 3 or 4 attorneys here. I don't know who.
it's going to be the same deal as you had before, I'm sure. Although the room will not be filled, I'm sure on Zoom or whatever, there's going to be all kinds of people on. And frankly, if I was Wolf, I don't know if I would do much other than all the testimony of 600 pages in the Section 302 hearing, just incorporate into this hearing. I'm done. Thank you very much. He might just be that quick with it, if you will.
He could be. Well, he could be. Right.
And the other lawyers could do the same. And all of our objections and all of our witnesses in the section 302 hearing, we ask that be incorporated into this matter.
If in fact we have to continue it. I don't know if that's going to be the case, but then I think that we really should possibly look for another site and then go through that again. Not anything other than, I'm thinking right now, the fire company, we could probably comfortably seat 25 people there, social
So
distance.
the advertise is going in tomorrow.
I know, I say if it's conditioned.
Oh, if
Or
no,
continue.
conditional use here. Oh, okay, good. Because it would be tight to get a new ad in, et cetera.
No,
Plus the ads like this, I mean, it's, you're already gonna spend $10 bazillion on the ads you did for the section 305 ordinance for Smithfield Gateway. Now you have large ads again for the economic development zone, so
What's the time frame on a conditional use?
there would be no time frame. Once you determine that it can be proceeding as in a conditional use, then in theory, they have to file an application for a conditional use hearing. Not a big deal. It's a one-page form that we see all the time, but they gotta file that, pay $1,500 or whatever the fee is, and then the 60 days will start to
Right,
run
that's
at
what I
that
mean,
time.
60 days.
Same deal, 60 days.
Yeah.
Same thing with this, it's 60 days for the municipal curative amendment
60 days expires on.
on August 11th.
Right.
So we gotta proceed on August 11th, so I'm hoping there's no
snow.
major thunderstorm or something that's gonna be a problem, because that is the 60th day. Although Wolf has been relatively cooperative, I think that if for some reason there was some emergency that we'd have to push it back, I would think his client would give us some additional time. I don't know that for sure, but I would think so. Like he did the first time. If you remember the first time, they gave us an additional 30 days for that conditional use
And then
hearing.
they turned on us and said we didn't act in a timely manner,
Well, it was,
perceived approval.
but what happened was that the objectors then put a stay in, so, we couldn't do much with that.
Okay,
But in any event, so I don't know what happens with that argument that's scheduled in August. Remember, there's an argument scheduled in August, I think the end of August sometime. So whether that occurs or doesn't occur based upon this recent turn of events, I don't know. And then remember, you and I are Allentown on the 7th of August, I think.
well, maybe not.
So,
Yeah,
or maybe not, I don't know, but
Is that still on
that's still on as far as I
in
know.
Allentown?
Yes. Yeah, that's still on.
Their
Because
courthouses,
the bank's attorney doesn't want to do it via Zoom. They believe that you don't get the same effect as holding feet to the fire without a judge or mediator actually staring at everybody and saying, you will settle this, blah, blah, blah. As opposed to on Zoom. It's like, when I used to date when I was a young guy. I used to hate to call people up on the phone because the girls could literally say, here, see you later.
But given the
Sure.
governor,
Click.
given the
It's
governor's,
harder if I'm there asking them,
given the governor's state of emergency, how can one insist on a face-to-face meeting?
Well, again, a petition can be filed with the court to request that it not be a face-to-face meeting. But when I say petition, request for, rescheduling, et cetera, but this would be the third rescheduling, and I think Williams will have about had it. I think he's about had it already.
but it wasn't
Just
us.
scheduling and no, but it doesn't matter whether it's
We
us or
didn't make
not.
this
But,
request.
because he's scheduling the motions for continuance, motions for summary judgment within 30 days of the mediation, et cetera, et cetera. So, I mean, it could very well be that I could even attend and maybe you could stay here via Zoom perhaps. I don't know.
Well, I don't think I have any problem. I don't know how the Lehigh Valley is going now. And things change, but that's
So
all.
right now, the Lehigh Valley is probably better than almost any other place in the state. Their numbers are very low.
That's good there.
Northampton, very low. Lehigh County, very low. In fact, there was a move filed by the local merchants just yesterday. The restaurants that are now back to 25%, they were 50%. A petition saying, hey, It's not us. We're doing better than anywhere else in the state. It's Pittsburgh that's the problem or whatever. We want to go back to the 50%. And they filed that request with DCED. I don't know where that goes. But there's a big move afoot that, you're penalizing the people that are doing the right thing and not having a problem. But anyway, you and I will go together. All right, you and I will go. You can drive to my office and we can go down together. We can have these guys on the standby phone, but we can't have two go because that's a potential issue. And make sure, like when you guys went to see Germano, that could be a little dicey there with two guys talking to him about a sunshine issue. So keep that in mind.
Before we adjourn, I'd just like to bring up something else that Ron mentioned, I think a few weeks ago, which is being inundated with emails. And I think just looking at what goes on, we seem to copy him on a lot of things that maybe he doesn't need to be copied on, or we could think twice about, because I can understand how trying to run his practice and do business, answer questions, the amount of email is just enormous. I know what we go through.
Well, just
And imagine what
between
you
just
do with
between the
five
three of
townships.
us.
Well, it's not a matter
It's your
that
call.
I can handle them. It's just a matter I can't read them right away. It usually takes a day or two. So if it's some emergency, I would ask that you call me either on my cell or there. But other than that, again, I went through all of them today. I looked at the emails now. In the last 2 weeks, this is this thing. Because I have all that Shriver stuff, I don't look at that Shriver stuff. I can tell you guys that. You look on your billing, you might get maybe a quarter of an hour, a brief review. But that Shriver file with the right to know stuff and water damage files, whatever, I bet you I must have this much paper on that file.
I also
But
know,
that's what you're paying the insurance attorney to do. So
Well, let
why
me
should
tell you
pay me?
that I have actually spent a hell of a lot of time in that.
Yeah,
on
well,
that
she
file.
just came up a couple of weeks ago where she had I
She
think,
was
sit
just
down
here
and
recently,
review with
second
you or
week.
whatever.
But that's only the.
So I'm
three of
okay
us.
with the emails. If there's a problem, I'll let you know. Just understand that I can't read them every day usually. So if it's something that you need a quick response on, you gotta call me. That's all.
So we had to look through 2,048 records is what we're coming up with for.
Now, is that
for Sarah.
ridiculous?
Yeah, it's quite a bit. And that's
You know,
just one request.
That was just one.
Right, exactly. It's just, that unfunded mandate is killing all the municipalities I represent. Upper Mount Bethel Township, they had to produce 1,300 sheets of paper because of a right to know request, wanted the check register, general ledger, and all that stuff. Well, none of that can be given to them electronically because that would be the violation of our license with QuickBooks or whoever we have. So it had to all be copied, all put in, page by page. And again, the government or the people of Harrisburg pass these laws without saying, okay, and here's some money, by the way, to do this.
Right.
No, it's as I say, an unfunded mandate.
Totally unfunded mandates. And I'm getting to the point right now that the new attorney that we're working with, she's pretty sharp, Sarah Argo.
Sarah Argo, yeah, she's very sharp.
And she's going to be working with the gentleman who had been up here before and kind of talked and briefed us. She has total confidence in him also, but the whole thing that we try to put together and present reasonably, that Elliot came back and said, no, that's not going to do it. You can't.
If you don't have a reasonable people on the other side, it becomes difficult to.
Or a judge. I mean, she went to the
decide.
judge and asked for
Okay.
some of this to be
We all have to be reasonable,
superfluous.
even with the two of you guys, on odds at whatever, we all have to be reasonable. We all have to say, okay, what's the right thing to do here and move forward? And if the other side, same thing now with this mediation with the FNCB bank, whatever. I don't know if this guy's gonna be reasonable. Does he want us to fix every road and every stormwater issue there at that thing? That's over a $350,000 bill. So
Yep.
when you talk about, this money here for this and this money here for that, there's another, someone's gonna reach into the township's pocket. So we'll just have to see.
Big time. Big time.
Anyway, that's far cry from where I wanted to be. I just wanted to give you guys reminders as to what's coming up, that's all.
Okay. Okay, anything else?
I make a motion that we adjourn.
Second,
All in favor?
aye.
Aye.